Oh, hey folks, elder law care attorney Patrick Kelleher coming to you from elderlawcare.com. Folks, very, very important question here today from one of our YouTube subscribers. Hey Patrick, do we need guardianship over our disabled loved one? And folks, the answer depends, because if you do not have guardianship over a disabled loved one, it could be detrimental to manage their medical affairs, and in some states, even the financial affairs. Here in the Commonwealth of Massachusetts, it's a dual office capacity. You're wearing dual hats: guardianship to manage medical and healthcare affairs, conservatorship to manage financial affairs. Folks, from my experience, depends on the client. If you have a loved one who's 18 or over and they have legal disabilities, folks, it can be very detrimental if you do not have proper authority legally over their financial affairs and their healthcare affairs. A simple example would be clients I've worked with. They have a child who is been diagnosed with significant disabilities, and the law says once that child reaches 18 years of age, they've attained the age of majority in most states, and now the parents cannot get access to any medical records. They can't even get answers from doctors or the school or other organizations that they were able to get information from previously, because their child is now viewed in the eyes of the law as an adult. So you need to take action and do proactive planning. My first line of recommendation or advice to our client of ours is put the Big Six disability planning in place. Durable power of attorney to avoid conservatorships at the probate court to manage finances. Comprehensive healthcare proxy to avoid guardianships at the probate court, and so forth. And if your disabled loved one has sufficient capacity, depending on the nature and level of their disability, they may be able to pick up a pen and sign in front of the attorney, in front of a notary, to create these power tools or legal instruments to avoid disability probate. So that is the first line of defense. However, in a more significant disability situation, if it's clear the level of disability is significant enough where the disabled loved one does not have sufficient capacity, then yes, folks, you need to petition the probate court for formal adjudication of guardianship, to be appointed as the legal guardian of your loved one to manage their medical health care affairs. And then here in the Commonwealth and some other states, to manage their finances is a separate petition altogether. That my advice, recommendation, do them both at the same time. And you want to file the petition for conservatorship, and that's to manage finances of your loved one. So they need to be done when they turn 18 years of age. And sometimes people overlook it because sometimes they're able to get through in life without anyone challenging them. But from my experience, eventually you're going to need guardianship. Eventually you're going to need conservatorship if that person has significant disabilities. And another pro tip here: if you had a legal guardian, you're the legal conservator, manage finances for your disabled loved one, you ought to also communicate with the Social Security Administration office, because they're likely receiving means tested public benefits like SSI, supplemental security income, and other Medicaid type benefits and so forth. You ought to become their representative payee as well. That's a terminology the Social Security office uses, so you can properly manage their Social Security checks coming in each month, and also being able to call the Social Security Administration and get answers to your questions when needed. So folks, that is my recommendations right there on guardianship. Least restrictive means, if you can put a plan in place with your estate elder law special needs attorney, power of attorney, healthcare proxy, then you ought to do it. However, if the disabled person does not have sufficient capacity, if their disability is significant enough where it would warrant a formal proceeding at the probate court, substituted judgment, formal proceeding for guardianship, conservatorship, then you need to take that route as soon as possible and work with a qualified estate elder law attorney in your jurisdiction that can assist you with that process, because it can be rather complex. So folks, there you have it right there. If you'd like free educational resources, go to our website, elderlawcare.com. I have a new educational webinar you can watch there, and I have a new tool called Ask Elder Law Care. You can plug in your questions there, even special needs planning questions, and you'll get an answer instantaneously. Folks, thanks for joining us here today. Click the subscribe button and the notification bell, because I will keep you updated on new videos and educational elder law special needs planning tools coming up in the near future. Hope to see you again soon.